So let's say that you are married and you have two children and you have a piece of separate property. You have a home that is a piece of separate property in the state of Texas, and you unfortunately become deceased and you do not have a will. Who do you think is going to inherit that separate property between your spouse and the two children?
Oh, that's a great question. I would think, first of all, my separate property that I purchased before marriage, I use my money to pay for it, or I could use my parents' money to pay for it. So I would think that if anything happened to me, that separate assets will go to my heirs. Most of people would think like that. Is that correct? Katie, let us know.
That is not correct. So like I know you said, like, let's say that your parents had helped you be able to purchase the property. So in that case where your parents had helped you purchase the property, if you didn't put them on the title or anything like that, if you don't co-own with your parents, they actually don't get your property. And that's something that is a little weird for some people because, that's what seems fair, right? So as far as separate personal property, or that's real property, because we're talking about a house here, the children, so your two children would take the entirety of the home equally. So in this case, one would get half, the other would get half. So as far as real property, your children would get to take equally, but your surviving spouse gets what's called a life estate on the home. What a life estate means is that that person gets to live there and be able to use that home for the entirety of either the remainder of their life, so until they die, or until they voluntarily leave. If they voluntarily move out of the home, then it'll go ahead and go to the children.
So my husband can live in my property in Chicago that I purchased before marriage, rent-free.
Yeah, I mean, it's a pretty good deal for that surviving spouse. And so it's the thing. Sometimes you can run into issues. So let's say you had a blended family. So your children are from a previous marriage. Your husband is your second husband, so it's a new marriage. Maybe there's, some animosity between, second spouse and first marriage kids. Even though there's that animosity there, that the first marriage kids have to wait for second spouse to choose voluntarily either to die or to choose voluntarily to leave that home for them to be able to take their claims and be able to sell that property. So it can cause some interesting issues, especially if people aren't aware.
So great. I got the first question wrong. So how about the second scenario?
So let's say we're in the same situation, but we're talking about not real estate. We're talking about your personal properties. So money that was in a bank account that you had before the marriage, or let's say that you had a mutual fund. So you have stocks. So that's something that you owned before the marriage. So the question here becomes, what do you think is going to happen to that separate property? So this is property that you held before you got married, and you have now deceased, you have a living spouse, and you have two children. What's going to happen?
It goes to my children.
That would be a really common sense thought. However, again, that's not quite how it works. So for your separate property, so that's separate personal property, which is defined as anything that's not real property being real estate or a home, it is 2/3 will go equally shared among your children. So here you had two children, so they would get 1/2 of the 2/3 and 1/2 of the 2/3. If you had 6 children, each one would take 1/6 of that 2/3. But it's in equal shares. And then 1/3 goes to that surviving spouse, even though this is something that you held before the marriage and was entirely in your own name.
Good to know.
So that might surprise you, but that surviving spouse does have a claim for 1/3 of that property that you held before the marriage. Now, that one in particular is one that confuses a lot of people because it goes kind of contrary to common sense, right? So if you've gone through all that effort to keep that property separate, you had it from before the marriage, when things like this happen, it can be pretty upsetting if people don't understand that that's the rule. So, for example, you could have something. So let's say that there was someone that had a marriage and their first spouse predeceased them. So they inherited something from that previous marriage. Then they get into a second marriage and then they decease and they have that remaining second spouse. That second spouse gets 1/3 of the inheritance from that first marriage. And that usually will really tick off the kids from the first marriage, because why would the second spouse get anything? It's because there's not a will. So if either having a life estate for the surviving spouse on a property or giving 1/3 to that surviving spouse is something that you don't want to do in any given situation, you definitely need a will, because in absence of a will, this is exactly how the state law of the state of Texas is going to administrate that separate property.
So the solution is, if I don't like this arrangement, you need a will, right?
Correct. Let's say that you pass and we're talking about the community property. So we're talking about the property that was in the community. So it's purchased with community funds. You've got 2 children and you've got a surviving spouse. So what happens with that community property? So your half of all those community assets, what do you think happens?
I think, well, 50% will go to my children because my husband already have the other 50%. Is that right answer or wrong answer?
It would be interesting and nice if that was how that worked, because that is common sense. However, the way it works in the state of Texas is if you have children that are from the same marriage, so let's say that your children are both from the marriage that you have with your current spouse, then 100% goes to the surviving spouse. Nothing goes to the children, because there's an assumption that that surviving spouse is going to give to the children when they pass.
That makes sense. Everything goes to the spouse.
The surviving spouse. So it is interesting because if you don't have a will, if you worried about your kids as far as them being able to take part of your half, or whatever it is that you have in that community property, you need to go ahead and write a will, because the way that the laws of the state of Texas work is they won't take anything. Now, one thing to worry about is the law kind of assumes that you're going to stay married for the rest of, or that spouse is not going to get remarried. But if that spouse is to become remarried and there are children from a previous marriage, then things become more complicated.
More complicated. Yeah, if the surviving spouse get remarried and then he has children with another spouse, and then this will create a complicated situation that you put your kids in the situation with his kids from another marriage, and then they have to split your community property equally. Right? That sounds unfair.
Let's say that you are the decedent, you have children from marriage 1, and you have a second marriage, you have a surviving spouse in the second marriage, and you have 2 children in marriage 2. So you have 4 children total, 2 from marriage 1, 2 from marriage 2. You have a surviving spouse from marriage 2. What happens with that community property?
I think it goes to 100% goes to my surviving spouse.
Yeah, so that's what would happen if you had one marriage, but remember that previous thing that we talked about. Remember, we write out those children the first time. So in the first marriage, the children don't take anything. Well, the state of Texas wants to guarantee that they'll get something. So if the decedent dies without a will and they have children from 2 different marriages, then the children they all equally take. So in this case scenario, we had 2 children from marriage 1, 2 children from marriage 2. Everybody will take 1/4 of your half interest.
50%.
Yes. And the surviving spouse gets their 50%. They get 0% of your 1/2 because it goes entirely to your children. The reason that the rule is this way is it's trying to guarantee, if you did have the scenario that we just talked about, where in the first marriage, spouse from marriage 1 passed, because the surviving spouse got 100% and those children didn't get to take from the parent that died first, it guarantees that they get to take from parent that died second. And so it's an attempt at fairness for children that would be in that scenario. But it is weird that when you die, if you only have the one marriage, the surviving spouse takes everything, children get nothing. Whereas if you have children from 2 different marriages, suddenly all the children take equally and the surviving spouse gets nothing, but they retain their 1/2 interest.
My husband will get nothing. We will get the other 50%, right? Or
he gets nothing. So they will retain their undivided 1/2 interest, but as far as your 50%, they get nothing.
So to summarize, if you don't like those arrangements, and if you're one of those scenarios, and you think the local rule is not fair or it doesn't make sense to you, you want to have your own separate arrangement, you should go ahead and make a will. So if you have a will, then you don't need to follow the local rule.